Welcome to Holland Estates. You are listening and watching episode number 584. Today we're going to be discussing, very interestingly, a Supreme Court of Canada decision called Threlfall and Carleton University that stems out of a Quebec case, which we don't often have the opportunity to talk about Quebec decisions, so that's a nice twist for us today. And the reason why, even though it is a Quebec case, the reason it has some interest for us is that it deals with legislation that's very similar to our Declarations of Death Act statute, and the question of retroactive payment of pension benefits that were paid post-death, but pre-declaration of death.
Yeah.
So why don't we'll get into the facts a little bit now.
So the facts are quite interesting in this case. The matter has to do with the retired professor of Carleton University, George Rosen. He disappeared in September 2007, but his remains were not actually found until July 2013. So the specific dates are actually, I think he went missing September 10th, 2007.
Mm-hmm. He went for a walk, apparently.
Yeah.
He was suffering from Alzheimer's.
Early stages, yeah.
Right, early stages, went for a walk and never returned, which is quite sad. And they searched and searched for him for several days and could not find him.
Interestingly, his remains were later found on the neighboring property, but
I found that so odd. But
it's quite sad.
It is
really. His remains were found in July 12th, 2013. But during this intervening period, while it was unknown whether he died or not, his de facto spouse, Miss Threlfall, received correspondence from Carleton University saying that his pension payments would cease, and the specific provisions of his pension were that they would only be made during life. And so when Carleton University communicated that decision to Miss Threlfall, she actually told them, well, you actually do still have to make payments because he is presumed to be alive under Quebec law.
And just for context, I think that Carleton's communication with her on this point was around a year or two post the date that he went missing. So he wasn't found until less than 7 years later, around almost 6 years later.
Yeah.
But this was only within a year or two later.
Yeah, and so she wrote to them and said, he's presumed to be alive. And in fact, it says, so an absentee is a person who, this is under Quebec law, while domiciled in Quebec, ceases to appear there without giving news of himself or herself and without it being known whether he or she is still alive. And so an absentee is presumed to be alive for 7 years following his or her disappearance unless, and that word was found to be quite important by the Supreme Court, proof of death is made before then. So Ms. Threlfall pointed out that there's no proof of death, hasn't been 7 years, pay up.
Right.
And so they continued paying.
They continued paying. I think it was really out of an abundance of caution.
Under protest,
Under protest, and without any admission that the money was actually owing.
That was smart of them at the time, for sure.
And so then, fast forward another 3 or 4 years, and the deceased is found, and Carleton University brings a claim against Ms. Threlfall seeking repayment of all of the pension payments she'd received for all of those years, and it's quite a hefty sum. It was a total of almost $500,000.
Yes. I think an important point is that he was found on July 12th, 2013, but it was determined that his date of death is actually the day following his disappearance, so September 11th, 2007. And so the question is proof of death retroactive, meaning does Ms. Threlfall have to fork out nearly $500,000 to Carleton University? Because otherwise they wouldn't have made these payments because he was dead.
Right. So the outcome at first instance, Carleton University was successful throughout. Right?
Yes.
They were successful, and the matter was appealed and further appealed to the Supreme Court of Canada. But at the Supreme Court there was a dissent by I think at least 3 of
Justice Cote and
Muldaver and one other 3 of the judges. And but long story short, it's a very dense decision, a very long decision. But the long and the short of it is that the court agreed that Carleton University is entitled to repayment of the funds back to date of death.
Yeah. And it was pointed out, of course, in the fact that, Ms. Threlfall, paid off her debt. Like, she used the money as she was moving forward. So, obviously, this is going to have a significant effect on Ms. Threlfall because she now has to figure out how to pay this money back to
Mhm.
Carleton University.
No doubt also all of the tremendous legal expense that it's
Oh,
costing.
no doubt, going to the Supreme
Yeah.
Court
Yeah.
with that, for sure. And
Yeah.
so the court basically said the true state of affairs is that he died, and that rebutted and superseded the presumption that the absentee, the professor, was alive.
Right, and interestingly, it seemed to turn on the wording of the policy is, right, he's entitled to payment for life, right,
Mhm.
until he's dead, not until he's declared to be dead,
Yeah.
right? Or he was certified as now having been deceased. So it's retroactive instead of prospective.
Exactly. Interestingly enough, they carved out, payments that would have been made by the professor while he was presumed to be alive. So that would be mortgage payments and that kind of thing. But they found that Ms. Threlfall had to pay back the pension. And so one of the things that the court considered was the wording of the Quebec legislation, and that's why I said earlier that unless was important, because they said it said that the absentee is presumed to be alive for 7 years unless proof of his death is made before then, not until proof of his death is made, meaning that this is very much a presumption, it's not a fact. And paragraph 45 of the decision pretty much summarizes that position really well. It says the presumption of life is nothing more than a simple presumption, and simple presumptions are not permanent sources of rights. It's a legal presumption of a fact. It's not equivalent to the facts itself. So when it is rebutted, it falls away and is replaced with reality. The reality being that the professor has been dead since his true date of death. So that was an important point made by the court, amongst other things.
Yeah, I mean, it is so dense, we don't have the time in this short podcast to get into all the detailed legal analysis, but, I mean, in terms of the equities, what sort of jumped out at me is, I mean, the result in one way seems so unfair because they agreed to continue paying this money, and she was getting it every month for years, only to suddenly be faced with having to pay it back, but the flip side of that is, she probably knew he was deceased. He had Alzheimer's, he went for a walk, never returned, and to have resisted the initial attempt of the university to stop payments,
Yeah.
I mean, I don't know how much that played into the analysis, because it certainly, on the face of the decision, doesn't seem to have. But when you just think of the equities, I mean, it's otherwise a huge windfall for her,
Yeah.
right?
No, for sure. The smart thing would have probably been to keep the money, to set it aside until
Right.
there could be some certainty there, especially when
Right, you've hit the 7 years,
Yeah.
and then
Especially-
you can
Right.
do as you please.
I think the court did talk about, because one question that I had in my mind was, okay, well, what if the remains were found after the 7-year period, and then it was determined that he died a day later? And I think that they commented on the fact that in that case she would have probably been okay. I think it's that 7-year period where
Right.
there's some uncertainty. So I think that unless you can get clear advice that you can use this money, the smart thing would have probably been to set it aside.
Right.
And I think that that's really why this particular decision may be relevant to us, because in Ontario we have the Declarations of Death Act, and it's actually also a 7-year period.
Right.
It's not worded in the same way. It's really that you can bring an application to the court
Right.
for declaration once it's been 7 years. Declaration of death, so it doesn't operate quite the same way. And I think that the contract here really was important because it was so unusual in its
Right.
wording, because it was unclear.
Right, and didn't he also, because he only was getting payments for his while he was alive, he was getting a higher amount in these monthly payments, and because they didn't
think
continue
so.
post-death, and so there was that sort of added benefit or windfall, I guess, to her.
Yeah.
I mean, the courts, right? They don't generally, I guess, like to allow windfalls. It's like when there's a payment that's as a result of a mistake of fact, right? That where let's say an executor pays out beneficiaries estate monies through a mistaken payment, those beneficiaries are typically required to pay it back.
Well, that was another actually point made by the court, was the payment made in error. So that was another ground. One of them was the wording of the provision, and then there's the whole argument made by Carleton University. It was made in error, and the court agreed that that was the case here. And I mean, what does that mean here? people in Ontario also have to think about the provisions of the contract having to do
Right.
with these payments, and really think about what they're receiving when, as a potentially on behalf of a person who's missing, and how they can insulate themselves from potential liability in a situation like this.
Right. Because you do certainly feel for her that
Yeah.
she's now got a hefty debt she's got to deal with, and it's a personal debt, because the litigation, even though she's, I guess I forget the term in Quebec, but she's the equivalent of the executrix of his
Yes.
estate, and
Yeah.
but she was also sued personally and found personally responsible.
Yeah. And I think she appealed that, but then that they decided not to pursue that at the Supreme Court level. So I think that it was to the ground that she wouldn't be personally liable. It was not pursued.
Right.
So that this is a lot now. So there's a very helpful article from Canadian lawyer by Elizabeth Raymer that summarizes this decision called "Proof of Death Can Be Retroactive. SCC decides in Carleton New Pension Case." We'll add that to our link there with our podcast.
Yes, and it was just recently done at the end
Yes.
of October. So I think that concludes our podcast. Until next time, we want to thank you for listening and watching. I'm Natalia Angelini.
And I'm Kira Domratchev.
Should you have any questions, please email us at webmaster@hollandhall.com or leave a comment on our blog. Thank you.